Drummond, please proceed.
Mr. Chairman, members of the board, I am Gentner Drummond, Attorney General for the state of Oklahoma. With me today are Assistant Attorneys General Christina Burns and Samantha Backett. Also at the table, Jennifer Crabb. Also present is former Oklahoma County Assistant District Attorney George Burnett, one of the original prosecutors in the case against Mr. Wood. Before Ms. Burns and Ms. Baggett outline the details of Tremane Wood's crimes, his ongoing criminal activity, and the reasons his request for clemency should be denied, I want to take a moment to underscore the duty entrusted to this office, the Attorney General's office, and that is to ensure justice is served, the public is protected, and the families of victims receive the finality and accountability they deserve. Tremane Wood represents the very kind of violent offender that threatens the safety of our communities. The crimes for which he was convicted are not acts of desperation or impulse. They were deliberate, predatory attacks on innocent strangers who crossed into the path simply because they were seen as easy targets. Arnold Klainsasser and Ronnie Whiff were two young men celebrating New Year's Eve in 2001, as so many Oklahomans do each year. For them, that night ended in unimaginable terror and tragedy. The murder of Ronnie Whiff stands as a horrific reminder of how cruel and calculated one individual can be, and the evidence proves that Tremane Wood was Ronnie's executioner. In the aftermath of that crime, law enforcement officers and prosecutors carried out their duties with precision and integrity. A jury of Oklahomans reviewed the evidence, delivered justice, and held Mr. Wood accountable. Every appellate court that reviewed this case has affirmed those findings. As these individuals carried out their duties, and even within the confines of a maximum security prison, Tremane Wood has continued to manipulate, exploit, and harm others. His pattern of violence and deceit has not ceased, it has merely adapted. The same vicious intent that fueled his original crimes endures today, revealing a hardened, unrepentant mind driven by deceit and a complete disregard for human life. Tremane Wood's story, mindset, behavior have not changed. Only his setting has changed. The danger remains as clear and present as ever, and no prison cell will protect society from his evil and ongoing deeds. Now, clemency is not a right. It is an act of mercy considered only for those who, at minimum, demonstrate genuine remorse and moral transformation. Tremane Wood has done neither. His continued predatory conduct reveals a recidivistic and deeply malignant mindset, one that remains as dangerous behind bars as it was on the night that he took the innocent life of Ronnie Whiff. I deeply respect Ms. Birdwell and her passion and her comments, truly, but justice must stand firm, the rule of law must prevail, and the safety of our people must remain our highest duty. Mercy without repentance is not justice, it is permission for evil to endure. And as a state committed to justice, we cannot and should not stand for this. On behalf of the citizens of Oklahoma, I respectfully urge the board to deny clemency for Tremane Wood. I now yield the microphone.
Thank you, Mr. Chairman and members of the board. Good morning. My name is Christina Burns, and with me is co-counsel Samantha Baggett. We are Assistant Attorneys General from the Oklahoma Office of Attorney General. And also here with us, as General Drummond indicated, is George Burnett, who served as one of the original prosecutors on this case. And I would emphasize that any of the accusations that were made by defense counsel this morning, that this board can ask him questions about those, and that the courts have already denied any of those accusations. Also with us is Jennifer Crabb, our Capital Appeals Director, who is also available to answer any questions. True justice and accountability consists of imposing consequences for someone's actions. This includes punishing murderers for irrevocably taking something that was never theirs to begin with, the life of someone else. That is why we are here today, to ensure that justice for Ronnie Whiff's death is carried out. We've heard so much about Tremane Wood this morning, so much about how he is the victim of an unjust legal system which unfairly sentenced him to death for a murder that he claims that his brother, Jake Wood, actually committed. As you will soon see, Tremane Wood's current iteration of avoiding responsibility for his actions on the night of New Year's Eve 2001 consists of, among other things, attempting to resurrect meritless legal arguments, taking statements, facts, or circumstances out of context to suit his clemency narrative, claiming that he's always felt remorse, and even misleading his own experts about how he has truly reformed his life since his conviction. In contrast, we will now present you with the true, unvarnished picture of who Tremane Wood actually is. This is the portrait of a man that his attorneys do not want you to see. And why is that? Because there are so many aspects of this case and of Tremane's own behavior that simply don't match the narrative or persona that he is attempting to present. Accuracy is important, especially in cases of such magnitude as this. Our choices, far more than any other aspect of ourselves, show us who we truly are, because they inform our actions. And I submit to you that despite any claims to the contrary, Tremane Wood's death sentence stems from a series of choices that he and only he made. Before Ronnie was murdered, Tremane and his co-defendants drove to a Walmart in Oklahoma City, where Tremane selected 2 pairs of gloves and masks in preparation for his illegal activities later that night. Tremane, and Tremane alone, asked Brandy Warden to purchase these for him, and she did. These actions are indicative of conscious planning on Tremane's part. They don't support a claim that he was simply the puppet of his older brother, begrudgingly going along with whatever plan Jake had for that evening, as he would like you to believe. Lanita Bateman provided Tremane and Jake with a target for their first robbery of the evening, a pizza restaurant located in Moore, where Lanita knew the location of the money bag. As the group drove to the restaurant, Brandy Warden, who was also present in the vehicle, attempted to talk Tremane out of the robbery, even going so far as to offer him money. He rebuffed her request, telling her that he wanted money from both her and the robbery. These are not the words of someone who is simply following his older brother's lead. Eyewitness evidence established which brother wielded which weapon during that robbery. Specifically, Brandy Warden recalled that Jake's weapon of choice was a gun, while Tremane wielded a large, shiny knife. Notably, the owner of the pizza restaurant recalled that although both of his attackers were masked, the one wielding the knife was physically smaller than the one wielding the gun. These details will be present as identifying factors throughout the entirety of this case. This is primarily because Tremane's own mother confirmed that Tremane was physically smaller than his brother, making him fit the physical description of the knife-wielding robber. The pizza restaurant robbery, which was only yielded an extremely small amount of cash, was exceedingly violent in comparison. Tremane entered first, shoving his knife close to the owner's stomach and telling him, "This is a robbery," while Jake walked around the counter. At one point, when the pizza restaurant owner tried alerting police, he was severely beaten by Jake for his actions. Once the brothers had obtained all of the money that they could find at the restaurant, Tremane then chose to flee the scene with Jake to avoid getting caught. Despite the unsettling violence of this premeditated encounter, Tremane did not choose to part ways with Jake, Lanita, or Brandy that evening. Instead, he chose to ring in the new year with them at the Bricktown Brewery, where the second and more fatal half of the night began. At the brewery, Arnold Kleinsasser and Ronnie Whip took a chance on chatting up Brandy and Lanita, not realizing how dangerous a decision this was. Little did they know that this interaction resulted in Tremane devising a plan with his accomplices, where the women would agree to accompany these unsuspecting young men to a hotel as a lure for an eventual robbery conducted by Tremane and Jake. However, as Jake later explained to Tremane's jury, not only was this supposed to be a robbery for cash, it was also for thrills, or as Jake specifically termed it, daredevil type stuff, or crip shit. That's a slang term for gang shit. In fact, Tremane was so adamant that this robbery needed to happen, when Brandy began crying and having reservations over the whole plan, he grabbed her by the face, squeezed her cheeks together, and callously told her to suck it up. Once again, these are not the mere actions of Tremane simply following his older brother's lead. They are conscious choices that demonstrate that this plan was just as much Tremane's as it was Jake's. After the group drove to the Ramada Inn Hotel, they rented room 204, which was the last place that Ronnie would ever see. Once inside the room, phone calls were made by Lanita to Jake's pager and to the home that Tremane shared with his girlfriend, Casey Odell. This coincided with Tremane leaving the residence in Casey's car and not telling her where he was going. But we all know where he chose to end up. Outside room 204's door, clad in the mask and gloves that he had selected at Walmart earlier and wielding a knife. At this point, things inside the room became chaotic. But what we do know is that an intense struggle ensued between Ronnie, Tremane, and Jake. Both men took part in beating Ronnie, and during the course of the struggle, somehow he and Jake switched weapons during the encounter. This is the only way that Tremane can advance a narrative where he can claim that he did not personally murder Ronnie Whip. This claim is completely untethered to the actual evidence adduced in this case. To the best of his recollection, the specifics of these events were recounted to police by Arnold shortly after Ronnie's murder. Arnold's unbiased eyewitness account of what happened inside that hotel room is the most important piece of evidence that you are going to see in this case.
Ronnie opened it. You know why he opened it? He didn't know who it was. So he just said, get out of here. And that's when them guys come through the door with that guy with the gun, with the handgun, come through and told me to get on the ground and demand that money.
Which one has the gun?
He was the heavier set guy.
George, did you go to the floor?
Yeah, he told me to get down. That's what that one guy told me. The other guy went after Ron, the one with the knife. I remember they were struggling, and then that other guy left me after I gave him the cash. And I remember they were both on Ronnie. When they come out and tell him to live in space area, and I could see blood on his hand.
The money he gave to workers, where do you have that money?
I don't remember what he did with the money. But I know after they kind of both struggled with him, they come out into the living room area, and then they both went back in. That's when the guy with the knife that was struggling with Ronnie first come to me, and he demanded some more cash. Because I told him I gave the other guy, but he took my wallet and looked through it, couldn't find nothing. I know he hit me on the head with his knife.
Now, according to Tremane's clemency package, he would have this board believe that despite him wielding the knife outside the hotel room's door, during the pizza restaurant robbery, and during the initial struggle with Ronnie, that somehow he and Jake Wood switched weapons during this chaotic encounter. In attempting to convince you of this, Tremane employs confusing logic that appears to claim that Jake's hand injury was sustained because he had a faulty grip on the gun at the time that he tried shooting Ronnie. But this still places the gun, not the knife, in Jake's hands during the struggle. Despite what Tremane now claims to this board, logic and evidence tell us that the idea that Tremane and Jake would decide to switch weapons during a contentious and violent fight with Ronnie is far-fetched, to say the least. Logic and evidence also tell us that whoever gave the directive to, quote, just shoot the bastard, was not Jake himself, given that he was in possession of the gun, as evidenced by his hand injury. Notable other evidence supporting this conclusion includes the following. Which corroborated both Arnold and the pizza restaurant robbery victims' recollection that the smaller assailant wielded the knife, Randy Warden placing the knife in Tremane's hands throughout the entire night leading up to Room 204's robbery, Arnold's specific testimony that he never saw either of these weapons switch hands during the robbery, and appellate court opinions from both Jake and Tremane's trials that highlighted the fact that the state's evidence supported that Tremane, not Jake, stabbed Ronnie, given that the only evidence to the contrary was Jake's own highly uncredible testimony. In fact, the Oklahoma Court of Criminal Appeals, in reviewing Jake's case, also noted that this explained the different sentences that each brother received, as Jake's jury was instructed on two relevant mitigating circumstances during sentencing proceedings. The first was that there was evidence supporting that Jake was not the one who was not the actual killer who stabbed Mr. Whip, and the second was that Jake only testified on behalf of his brother to protect him. Tremane now claims that he experienced intense remorse immediately after the murder. This could not be further from the truth. Case in point, the only remark that Brandy Warden recalled Tremane making in the wake of the murder was that he didn't give a fuck about that peckerwood. Additionally, several days after the murder, instead of attempting to take responsibility for his actions, Tremane made another selfish choice. He made his girlfriend drive him, along with their young child, to Houston so that he could obtain money and avoid arrest. At no point during this drive, even when his girlfriend attempted to ask him questions about the murder, did he ever express any remorse over the incident. His only thought was how to avoid getting caught. After his arrest, Tremane continued to think of ways to avoid being held responsible for his actions. At one point, while incarcerated and waiting in jail, Tremane wrote a letter to Jake attempting to gain information about whether Jake was going to plead guilty, and more specifically, about whether he was going to say anything that would specifically implicate Tremane. This is actually one of the first glimpses that we get about Tremane's trial defense. He wanted Jake to take up for him by saying that he wasn't even present in room 204 that night. And that's what happened. And that was a lie that Tremane specifically advanced to avoid culpability. Now Tremane comes before this board and complains that the jury never got to hear about his sincere remorse. But in reality, they never heard about it because it didn't exist. How can you claim to be remorseful about something that you maintain you were never involved in to begin with? Once again, Tremane chose this path, and now when it is time to reap the consequences of his decisions, he blames anyone other than himself. Blame shifting is a running theme in many of the claims that Tremane makes to this board. Case in point, Tremane now attempts to blame Johnny Albert, his trial attorney, for the chosen strategy of Jake testifying on his behalf. This is belied by the trial record. In actuality, Mr. Albert and his co-counsel both strenuously objected to this strategy and tried convincing Tremane that it could backfire. Mr. Albert even made an extensive record to this effect, complete with the trial court questioning Tremane about whether he fully understood counsel's advice. What Tremane fails to admit to this board is that he and he alone charted this course of action despite his attorney's advice. And why is this significant? Because Tremane has since fully admitted to being in room 204 on the night that Ronnie was murdered, which is the exact opposite of what he wanted his attorneys to claim to the jury during his trial. Now he admits in his packet that Jake committed perjury by testifying otherwise on his behalf. In other words, based on these admissions and the trial record, Tremane was fully complicit in perpetrating a lie to avoid culpability. This was hardly Mr. Albert's fault, and in fact, Jake's own attorneys even made it clear during Tremane's started course of action could backfire and significantly harm both of the brothers' cases. Now that this claim has been debunked, it is also worth pointing out that despite what Tremane would have this board believe, a confession from Jake Wood that he was Ronnie's actual killer is highly suspect. This is because this is not the only time that Jake has attempted to confess to a crime and been thoroughly rejected by the court system. In Pavat v. State, Jake wrote a series of letters purporting to confess to killing the victim in that case, Rob Andrew. In finding the content of those letters uncorroborated and unreliable, the Oklahoma Court of Criminal Appeals noted that Jake's letters were wholly inconsistent with the evidence adduced in that case, and also noted that Jake had also attempted to confess to other murders as well. Suffice to say that relying on the veracity of statements made by Jake Wood as evidence that Tremane did not stab Ronnie is virtually meaningless, given that he clearly had incredibly problematic credibility issues. Finally, as to Tremane's other attempts to resurrect claims of ineffective assistance by Mr. Albert, most have already been thoroughly evaluated and rejected by the court system. These claims have also been fully addressed in the state's clemency packet. However, if the board has questions about this topic, the state is happy to answer them. In his packet, Tremane leans heavily on Jara Burton's post-trial testimony that she had initial reservations about handing down a death sentence and how she felt pressured to do so. Tremane claims that this pressure was facilitated by the trial court instructing the jury that its verdict had to be unanimous. In effect, Tremane claims that this resulted in a faulty death sentence in this case. This claim is inherently problematic for two reasons. First, it is worth explaining that in a 2006 evidentiary hearing, Ms. Burton testified that she would have potentially pushed harder against a death sentence if she had known about certain alleged facts presented to her by a defense investigator in the form of affidavits after the trial. This testimony was ruled patently inadmissible under Oklahoma law because jurors were not permitted to give testimony that impeaches or contradicts their verdict after the fact. Additionally, the trial court determined that Ms. Burton's testimony was also of little value, given that the affidavits that she relied on were presented out of context and without the benefit of cross-examination or the jury trial process. Despite her testimony that this evidence could have altered her verdict, Ms. Burton also had an extremely vague recollection about the specifics of the actual evidence that was presented during the sentencing phase of Mr. Wood's trial. She also never indicated during the hearing that she felt bullied or intimidated by the other jurors because of her race. These events from 2006 highlight how Tremane's claims about the reliability of his jury's verdict has evolved over time. This, in turn, casts doubt on their credibility. These events also demonstrate the pitfalls that exist when jurors are contacted after a verdict has been rendered and are questioned about whether any one piece of evidence, without the benefit of adversarial testing, would have potentially changed their mind. Such questions unfairly ask jurors to make ad hoc decisions based on a less than complete picture of the evidence in any given case. This is precisely the reason why it is impermissible for a juror to give testimony contradicting their verdict once the trial is over. If that were ever permitted, no verdict would ever be secure, no case would ever be truly over, and the jurors would be continuously harassed or questioned after the fact about their decisions. And this is what the state believes truly happened to Ms. Burton. This is not good public policy, and it undermines the entire criminal justice system. Finally, it should be noted that Tremane's claim regarding the trial court unduly pressuring Ms. Burton or other jurors into rendering a sentence of death is completely false. Tremane's jury was properly instructed that any verdict rendered was required to be unanimous. Additionally, the Oklahoma Court of Criminal Appeals has consistently held that any instruction to a jury informing them that the trial court will impose a life sentence in the event that they are unable to reach a unanimous verdict as to punishment is improper. This is because such an instruction has the potential to facilitate the jury avoiding its difficult duty of rendering a verdict on the life of any defendant facing the ultimate punishment. Suffice to say, the jury in Tremane's case was not misled in any way. As you've seen, Tremane Wood's series of direct personal choices led him to being convicted and sentenced to death. He also attempts to evade responsibility of them to this day. So what kind of individual makes these decisions? Early warning signs from Tremane's juvenile years show that he could be impulsive, aggressive, and act out in an antisocial manner, which can ultimately lead to antisocial personality disorder as an adult. Tremane also showed signs of character and conduct disorder, a precursor to possible future criminal activity. The closer that Tremane got to maturity, the more concerning these personality traits became. One evaluation noted that he showed heavy indicators of explosiveness, assaultiveness, and hostility. He also showed a disregard of how his behavior affected others. This evaluation also noted that Tremane exhibited characteristics signaling potential problems with authority and the potential for future criminal behavior. It also stated that Tremane exhibited personality traits indicative of self-centeredness, entitlement, and a tendency to manipulate and exploit others. It is worth noting that several months ago, Dr. Sean Robertson presented to this board an incredibly relevant presentation giving expert insight regarding the exact psychological issues that Tremane as a juvenile exhibited. Dr. Robertson explained that chronic juvenile offenders are more likely to exhibit criminogenic and psychopathic traits. Persistent adult antisocial behavior generally begins in adolescence, and it can be flagged in children with symptoms that include poor anger control, early developmental issues, early behavioral problems, manipulation of others, and a failure to accept responsibility. Dr. Robertson also told this board that adverse childhood experiences do not necessarily predict any future criminal behavior in any one individual, and that most incarcerated juvenile delinquents do have some form of conduct disorder. These points made by Dr. Robertson further support the findings made by those who evaluated Tremane as a juvenile. And as this case and Tremane's most current prison activities show, these concerning personality traits are unfortunately validated by his adult behavior. Tremane claims that his childhood experiences and chaotic home life growing up were circumstances that charted an unalterable course for his life and excuse his adult behavior for murdering Ronnie Witt. However, as our packet fully describes, when he began exhibiting gang-related criminal behavior in his adolescence, the state of Oklahoma attempted to intervene throughout his young adult life in an attempt to stem any dangerous to his welfare, as well as attempting to make sure that any delinquent or gang-related activities did not continue. Although these intervention attempts were not perfect, it cannot be denied that Tremane was given the benefit and opportunity to participate in numerous programs designed to provide him with the skills to navigate his chaotic home life environment. Unfortunately, these programs are not designed to provide a mechanism for watching over Tremane's shoulder indefinitely. At some point, as part of growing up, Tremane was charged with taking the skills that he had learned in these programs and channeling them into making good choices on his own. And he showed that he could do that for limited periods of time. However, he also showed the opposite. This included periods where he continued to engage in gang and perpetrate criminal behavior even when Jake was not in the home. Thus, what this juvenile and psychological history shows is that although Tremane exhibited concerning personality traits and was subjected to negative environmental factors growing up, the consistent back and forth between progress, good behavior, and then regression into delinquent, antisocial, and gang-related activities indicates that he had the capacity to maintain a positive path for his life, but he consciously chose not to do so. We all have the capacity to rise above our circumstances, and people do this every day. There are countless individuals who grow up in deprived environments who do not end up committing murder or becoming forever entwined in a criminal gang. If all of our futures were predetermined by our childhood experiences, that would leave zero capacity for free will, and it would also promote a tendency to avoid responsibility for our own adult decisions. To this day, the only consistent activity that Tremane engages in is crip shit and avoiding responsibility. Do not be taken in by his manipulation. Tremane's own autonomous choices are why we are here today. I will now turn the presentation over to my co-counsel, who will outline the outright damning behavior that Tremane has exhibited in prison, which clearly shows that he continues to have no qualms about continuing to victimize others with illegal and violent behavior.
Thank you, Counsel. Chairman, Mr. Chairman, and members of this board. As my co-counsel stated, Tremane Wood has two faces, that he shows to the public and this board, and the true Tremane Wood, as evidenced by the contents of his two contraband cell phones. To this board, he represents himself as a renounced Tuber Crip, nonviolent, not a troublemaker, a positive role model, a victim of prison culture, and having a remarkable ethos of accountability. In his packet, his counsel states that at times he has lost his way and made poor choices that he has come to regret. However, the state will show that this is a false narrative designed to minimize his conduct while in OSP, beginning with his recorded DOC misconducts. Beginning on H unit in 2004, which is the most secure part of OSP and death row, Tremane Wood accrued multiple misconducts, circling around his possession of cell phones, law violations, and disobeying OSP staff. In October of 2019, he and along with other death row inmates were moved to the general population unit, which is a less secure part of the prison. He was therefore given more freedom and more trust, and he abused that trust by continuing to possess cell phones, being disrespectful, and in June of last year, fighting another death row inmate. In a text message that he exchanges with one of his inmate buddies, he admits that he got kicked off the yard for punching on this one cat, and it sure did feel good to punch a face again. In June of this year, however, he was moved back to H unit based on his third cell phone that he was found to be in possession of, and while on that unit, he was refusing a drug test. He was continuing to possess cell phones. However, after he learned that this office had access to the previous ones, he broke those so that they would be undownloadable, and as well as possessing illegal substances. On two handwritten notes that were seized with one of the broken cell phones this year, it indicates that he has a continued gang affiliation. So this board, Tremane Wood, asks you to consider cell phones as part of daily life in prison, and that they are mainly to contact family, and that it's not the worst thing for inmates to do. However, this is again a false narrative. And I know that counsel has stated that all of these things that the state will present to you are carefully curated to paint him in one light. However, this is his true light. The information that was seized discovered that inmates, including Tremane Wood, use cell phones to distribute drugs, contraband, and coordinate illegal activity. So this board's cell phone should not be taken lightly and should not be considered normal. The real Tremane Wood is a 107 Hoover Crip. As you can see in this picture, he's throwing up several gang signs for H, meaning Hoover. Some of the language on the right picture, that cello is cello or Southeast Los Angeles. Orange and blue are specific colors to the gang. They are related to Houston Astros. 107, obvious for one of 7 Hoovers. And in his body tattoos, HC is Hoover Crip, 107 for obvious reasons, WSHCG, Westside Hoover Crip Gang, and the Houston Astros star. He would have this board believe that his connection to the gang completely disintegrated upon his removal from Jake's presence and by putting him in OSP. However, this is a false narrative. He continues to pride himself on being a member of the 107 Hoover Crips. The real Tremane Wood, as he was on the street, continues to be a Hoover trap guy who deals in drugs. As he tells you in his packet, a trap guy is responsible for drug trafficking for the gang. This was his role outside of the prison. He still continues to do this, given that he has more trust by being a run man on A unit, and he was responsible for passing things out to other prisoners. He violated this trust by evidenced by these text messages where he discusses with another inmate who is also a gang member that a new OSP female guard is now in A unit, and that it's best that they train her to the gang's benefit before OSP staff is able to train her. They state that Tremane is a model inmate. This is another false narrative. Next, with respect to him as a Hoover trap guy, he dealt primarily in cell phones as well as drugs. The common practice was to buy and sell cell phones, chargers, prepaid cards, and SIM cards that would be given to inmates, even in H unit, the most secure part, which would give them access to all parts of the prison in the world. If a cell phone was broken or taken by staff members, the practice was that he and other inmates would keep their SIM cards and put them in a new phone. With respect to him being a trap guy with respect to illegal substances, these are all defined in our packet. However, going through these quickly, K2 deuce or deuce is synthetic marijuana. Sheets and IDs or stamps indicate that pieces of paper that they are either sprayed with K2 or dipped in K2 and sold to other inmates to be smoked. Some of the adverse effects of K2 is an elevated heart rate or blood pressure, unconsciousness, tremors, seizures, and hallucinations. Many of these side effects of K2 are documented in videos found on Tremane's cell phone of other inmates at OSP smoking and getting high off of K2. Next is wax or dab, which is marijuana concentrates. These are dangerous in that they can contain up to 4 times the amount of THC content as high-grade marijuana. And finally, moon rocks, which is crack cocaine, and speaks for itself. With respect to Tremane Wood's contraband deals from February 2024 to May of 2025, he participated in 21 buys in which he bought substances for either resale or personal use, 42 sales in which he sold substances to other inmates or outside individuals, that's outside of DOC or another DOC facilities, and 12 cell phones, which are cell phone buys or deals of cell phones or cell phone accessories. With respect to illegal substance photos, Tremane had a practice of self-documenting all of his drug activity. The pictures in which he's holding bundles are all bundles that would be given to OSP inmates. The practice was to put inmates' identifiers or cell numbers on the bundles to be carried by runmen. K2, which is in the bottom left corner, and crack cocaine in the top middle. Next is sales of goo and moon rock, penitentiary vodka in which he's holding up Dasani and orange juice bottles, which is lean or homemade alcohol, as well as a 1 pound bag of Gucci that he elicited the outside help of an associate to go pick up. Finally, gabapentin and oxytocin that were given to him by an outside individual to sell and make money. And geek bars, which are nicotine vapes. There were also presence of marijuana vapes within the prison. With respect to Tremane's dealings as a Hoover trap guy, they extended beyond OSP walls. This was a deal in October of last year in which he told an outside individual to make him 2 zips or 2 ounces of THC wax. The individual told him where to tell an involved individual to tell their run man where to meet him, which is at a Walmart on the Northwest Expressway, as well as the time. They also exchanged vehicle descriptions. And then finally, Tremane tells his outside associate an Oklahoma City address so that he could drop off the money from that sale. Next is crossing state lines. This is also from October of last year. Tremane Wood became put in contact with an individual from California for the purpose of selling K2 sheets. Tremane Wood states that they have resources to get things to them inside OSP, and he's just looking for a good, solid connect. Tremane Wood purchases a couple of samples of these sheets from this individual and sends him an Oklahoma City address. And this individual says that he will send the tracking number as soon as it's done. And then Tremane Wood says that they have connections in Arkansas and they're thinking about getting books of K2 ready so they can really hit the system and sell K2. Again, this is who Tremane Wood truly is. He continues to be and was the Hoover trap guy. He is also a Hoover enforcer. beginning with his claim that he was just the trap guy and his brother Jake was the muscle in the gang. He has taken up the mantle as enforcer. Beginning with this Guthrie attack that was in December of last year. This was carried out against a man trying to have a relationship with Tremane Wood's 16-year-old niece. Tremane Wood contacts an outside friend who is involved in the gang and gives him the town and the specific neighborhood wherein this person lives. The friend responds that he'll look into it. Next is an attack that defense counsel referenced, carried out and ordered by Tremane Wood and carried out against an individual who is an inmate in Holdenville prison, serving a sentence related to the murder of Wood's friend's cousin. In July of last year, he contacts a friend who is a gang member over at Holdenville and says that he needs an inmate and sends these 2 pictures of the inmate touched up and asks him to get it on film. He says that he will send money through Cash App when it is complete, and the 2 exchange Cash App information. In August, an inmate over at Holdenville is able to confirm that he has located this individual, and Tremane Wood reiterates, "Smash him, bro, for real, smash. Get it on film, bro." And finally, he gets confirmation that the attack is complete in September, and I would warn you, the video is graphic. He also receives a picture confirming that the inmate was attacked, showing the inmate bloodied in his cell. The audio, there is not much audio, but towards the end of the video, you can hear one attacker telling him, "You better not tell," and the inmate says that he won't. After this attack is carried out, he sends his friend reassurance that his guys are still pressuring the inmate by stating that they're still on his helmet, and then he finds out which inmates carried out the attack so that he can pay them. And then he acknowledges finally that it was a Hoover attack based on his friend saying that his guys have fun doing Hoover biz, and Tremane Wood responds, "Birdwell, bro, Hoover salute." Again, Tremane Wood is a Hoover enforcer. His counsel claims that he is not violent, he is not a troublemaker, and they would ask you to view his actions through the context of prison culture, not his character. However, I would ask you to ask this Holdenville inmate about the content of Tremane Wood's character and character for nonviolence. It is evident from looking through his cell phone that he has unfettered access and ties to DOC and the outside world, and that should trouble this board because drug distribution and ordered attacks are all things that Tremane Wood and his friends could do to anyone in the public. His counsel further states that Tremane Wood has made poor choices that he has come to regret. However, based on videos and pictures captured on Tremane's cell phones, the ones that he took himself, I would ask this board if it looks like he regrets his poor choices. He gets to party it up with his Hoover friends, buy any substance he wants, and he can earn money by slinging dope and can up his street cred by ordering attacks. Again, does it look like he has a remarkable ethos of accountability? No, he enjoys getting to do crip shit. His life hasn't changed since it was how it was on the street. He still gets to do the same things, but the lives of Ronnie Wood's family and Arnold Kleinsasser are forever changed by the actions of Tremane Wood. Today, his counsel would have you believe that he is truly remorseful, that these were lapses in judgment, that he has spent his entire time in OSP working to better himself, his education, his mental health. However, I would submit to this board that those are all hollow words. This is the real Tremane Wood. This is the unvarnished, unfiltered, unmasked version of Tremane Wood of who he really is, based on the contents of his cell phone and who he chooses to be when he thinks that no one is watching. On behalf of the state of Oklahoma, we respectfully request that this board deny clemency. Thank you.
Let me check to see if the board members have any questions. Are there any questions by any of the board members?
A couple. Just what we saw. The continuing threat aggravator come to life on the screen, and I don't doubt that. But to me, it's a death penalty case, and it's about the legal process of getting there. And I have to ask. There's some questions. The failure to give the jury instruction that clearly decides or defines what the state must prove in order in felony murder to have a death sentence. That's criminal jury instruction 4-71. That was not given in this trial. Is that accurate?
Yes, that's correct.
All right. And as I can tell down here at the bottom of that jury instruction, I'm looking at on my computer, it was in effect as of 2000, at least, the year 2000. This trial was after 2000, right?
Correct.
All right. And so, clearly and apparently, Attorney Mr. Albert didn't do his, not insisting that this jury instruction be given. Is that a fair statement?
He should have requested that it be given, yes.
Right. And let's take the other side of that. I mean, I've been a criminal defense attorney. I've been an elected DA. Isn't it a prosecutor's ethical obligation to make sure that a trial is fair?
Yes.
And is there anywhere in those ethical obligations that suggests when the defense attorney is failing his job, that the district attorney's job is to still make sure that's a fair trial?
There is not any indication of that, no. That is not the law.
And would I be off base in my belief that a district attorney prosecuting a murder case, seeing that the defense isn't asking for this instruction, shouldn't I ask for it myself?
Yes. Could I address the absence of the instruction, the effect of it?
I'm sorry?
May I address the effect of the absence of that instruction?
Well, let me tell you what, at least what I have seen in the submissions, it appears, and I've read in the opinions following this case, that the Court of Criminal Appeals essentially did a factual analysis of option number 5. That there's proof that the defendant was a major participant in the felony committed and was recklessly indifferent to human life. The Court of Criminal Appeals essentially find the facts supported that. Isn't that what they did?
They did, and that's certainly the case given his admonition to his brother to just shoot the bastard. You know, even setting aside our very strong belief that Tremane is the one who stabbed Mr. With, if nothing else, he told his brother to kill Mr. With.
And I don't disagree with those statements. But this is about the legal process of seeking the death penalty, at least for me. And this benefit it gave the state in closing arguments is their corral of how they could be contained and what they had to prove before the jury, that this corrals them. The jury instruction limits what they can say and do, or at least requires them to do certain things, and the jury doesn't have this back in the jury room to review and look at.
True, but the state's position was that Tremane is the one who stabbed Ronnie With, and so that question was squarely before the jury. And no trial is perfect, but we do have provision for harmless error in our system, and in this case it's hard to imagine an error that could be more harmless, where, as I said, even setting aside the idea of who actually stabbed Mr. With, who was Tremane, but even setting that aside, he told his brother to kill Mr. With. There's no question as to what his intent was.
And I'm going to presume, based on my experience, that there was a legal ruling in Jake's jury trial that the prosecutors in Jake's jury trial could not be questioned, could not be quoted, having made the adamant claim in Tremane's trial that Tremane was the killer. They were allowed in both trials to argue that both men were the person who caused Ronnie's death.
My understanding of what the instructions were, or what the ruling was in Jake's trial, is that the trial judge instructed the prosecutors that they could, I don't believe that they could directly implicate Mr. Wood in as having stabbed Ronnie. They had to argue it in the context of felony murder, if that makes sense. That either one of them, regardless of whether or not who actually stabbed Mr. Whip, that either one of them could be equally guilty based on the actions, on either of actions that night.
I'm not sure that's what I read in it. It's the transcript I have that I'll accept that.
Counselor, I have a question. Usually, I mean, obviously, anytime there's a murder committed in our state, I mean, we're all victims in a sense. But in this particular case, I mean, and usually death penalty cases, we have testimony from family victims. We don't have that in this case. Would you go ahead and address that to the board?
Sure. That is correct. I mean, our understanding of the victim's position in this case is that they did not want to be involved. They also wanted to see justice done, and they left that to the Attorney General's office to seek justice for Mr. Whip, and that's our position.
All right. And then on this Albert, the attorney Albert, when he submitted his bill for $10,000 to represent Tremane, is his assertion that other than appearing at the scheduled conferences and trials, and that he used 2 hours of preparation? Is that the way I read his affidavit?
I can't speak to, his understanding of what he thought of when he put in that affidavit. But what I can speak to is that during Tremane's trial, and during the evidentiary hearing in 2006, there was a lot of testimony elicited from Mr. Albert about the amount of time that this case had come before Judge Elliott, about how that he had spoken with Tremane and his family almost every single time he did come to court, and that it was his practice at that time that he would typically meet with his clients either before or after court after proceeding.
Right. And I understand that. I mean, sometimes in public defense that is, but this is a death penalty case. This is not a nonviolent, property offense. You're asking, and the state of Oklahoma is asking the board to approve an execution of a man who's been convicted of murder. And not every inmate convicted of murder gets the death penalty. And so I think this is a little different case than your normal. Not that there is a normal murder, but when you're asking for the death penalty, there's a high standard. I'm not sure that this attorney met that high standard. And you can address it. I would like for you to, because it's embarrassment.
Sure. So sometimes there's no defense to be put on. We know today that Tremane Wood was in room 204 and participated in this robbery. And so except to the extent that he had to defer to his client, Mr. Arnold could not put on false evidence. There simply was no first stage defense to present. As far as second stage goes, the courts have looked at it. A lot of mitigating evidence was presented. And then, of course, we know that ineffective assistance of counsel has two aspects. One is what did counsel actually do, and the other is what was the effect. There's no reasonable probability that there's anything that counsel could have done, particularly after Jaitan Wood testified, that would have resulted in Tremane being acquitted in this case.
Well, I thank you for your answer. There is a constitutional right to counsel, and if you empty that of what that means, I mean, if the counsel, can only show up, for the hearings and the court appearances, you can kind of empty that of its essence. But I understand. And one thing you said that I do agree with is that sometimes we expect perfection in all of these procedural things, and that's not going to be had. So I understand that. But I just want you to know, because I've listened to several presentations, I've been, sometimes I vote yes for execution, sometimes I vote no. I want you to know that that's a serious question I have when I'm asking, did this man have adequate representation? So, anyways, I appreciate your answer, and we'll have to live with it.
I need to follow up with one thing. The closing arguments from Jake Wood's jury trial, page 23 of the transcript, prosecutor quoted, "He has killed a young man. He chose to take Ronnie Whiff's life. He made choices to murder Ronnie Whiff. He murdered Ronnie Whiff with a knife." Those are the statements of the prosecutor in the closing of Jake Wood's trial.
And I recall reading that as well. I think there was one objection to that closing argument, and it was a specific statement made by this Ms. Smith about having the knife and stabbing Ronnie, and that was objected to because of the court's prior limitation on what they could argue. I believe that the rest of that argument was deemed proper by the court. I don't believe it was objected to because there was a ruling that indicated that prosecutors could argue that regardless of who actually physically stabbed Mr. Whiff, the actions of both of those defendants that night was sufficient to constitute felony murder.
But they never argued this, that Ronnie was stabbed by Jake in Tremane's trial. They never argued that.
I honestly don't recall. I don't answer that. And I'm not sure if I may, that what you just read says that he's the one that stabbed him. I believe what Ms. Burns was saying is that what prosecutors were saying is that Jaitan did murder Ronnie Whiff, which is a legal matter, is true regardless of whether he stabbed him or not.
Further questions?
I have no.
Okay. Thank you. The board will now take it's now 10:55 a.m. The board will take a 10-minute break and we'll come back